Hola. En un minuto estamos
We will start again in 1 minute.
Si se acercan, por favor.
So if you please come back to the room, we are about to start. Why is the metaverse relevant for intellectual property? Megan Carpenter, University of New Hampshire, the United States. Micky Minhas, University of New Hampshire, United States. Moderator, Alonso García, Estudio, Echecopar, Perú. We welcome our next panel. They are
Buenos días.
Good morning. I am not an avatar. I am Luis Alonso Garcia. Allow me to make a brief introduction to this panel. Why is the metaverse relevant for intellectual property? But first, I would like to thank the ASIPI's board for their trust to allow me to moderate this panel with such excellent panelists. The challenge is huge because we not only have extraordinary speakers and professionals, but also because the order that we received, which is important and challenging, because the goal that we have is to try to understand concepts and ideas, and why not to try to get closer to the future, the legal future of metaverse with regards to intellectual property. Metaverse, that we've seen, is a new universe of three-dimensional experiences in which users interact with each other in an environment that mixes elements from two realities: the real reality and the digital reality, a space in which there is a total merger or immersion of users thanks to the developments that we've seen this morning, such as blockchain, virtual reality, augmented reality, Internet of Things, Web 3.0, NFTs. Undoubtedly, we are at the beginning of a new module for people to relate to each other's companies, brands, designs, and products, and a set of digital assets of high value. All of this is evolving towards a new ways of consumption and the future of dynamics of socialization, not just of companies, but of individuals themselves, as has been conceived by Mr. Mark Zuckerberg. I have to confess that, as many of you, it might happen in this issue of the metaverse, it makes us feel worried, not just because of what it could mean in to our profession or the business related to intellectual property, but probably because for many of us, in particular those of us who are over 50 years old and getting closer to the 60s, the technological panic can be bad for us, and it could make us blind with an augmented and virtual reality that's even more real than virtual, that is here to stay, and that it is revolutionizing and transforming interaction in the market of many stakeholders, many economic stakeholders. It is clear that the COVID-19 pandemic exponentially accelerated the transition to the virtual world, and this clearly is creating an important economic opportunity in the future. We definitely have to understand it and be prepared for it. A few days ago, Cecilia Falconi of the Brainstorm IP Club sent a copy of the news Fortune in which it showed how a product manufacturer for physical massive consumption present for 180 years in the market is devoting a lot of time and resources to the metaverse. So the question is why? Why are companies beginning to enter in this field? And the representatives of Procter & Gamble, which is this company, explained that all of this effort gears to finding new ways to interact with the potential customers and add value to them. In this sense, we are noticing that what has started is a fast race in which companies are beginning to design their digital future for these new business modules that have to do with the new relationships among businesses, consumers in a digital market that is promoting new ways of consumption with new identities, even called avatars. So we are going to be needing new strategies to attract customers both for digital assets and real assets. And this interaction is going to pose a challenge for the current legal systems. Faced with this, we have to ask ourselves if intellectual property is going to play a relevant role in all of these relationships. And we believe that it is so. And this is why this panel is geared to given us an overview on these topics and to ask about specific topics. What are the trends in the use and integration of existing intellectual property assets, and in what industries have we noticed these processes to take place? One new intellectual property rights would be creating in the metaverse. These are the intellectual property laws, the ones that have to adapt to the metaverse, or does the metaverse have to adapt to the laws on intellectual property? These are some of the questions that we hope we will be able to cover and discuss in this panel. And for this panel, we have invited two very special speakers, two professionals, top-notch professionals. We have Megan Carpenter. Megan is the Dean of the School of Law of the University Franklin Pierce, New Hampshire. In the School of Law that has had ranked #1 worldwide. She is an opinion leader in terms of intellectual property, technology, and education, and she has broad experience in the creation of institutions, and all of her story is related to the development of new income and innovation products, services, and policies based on diversity and inclusion, in addition to having published several books and a series of specialized articles. On the other hand, we have Micky Minhas, who is the Senior VP of the Marconi Company, where he works with a team, world top, a group of experts in intellectual property, creating and supporting platforms and licenses of patents that are independent for more advanced technologies. Micky has had a great experience in companies such as Microsoft, Wellcome, and he's been closely related to patents and innovation topics. He has a degree in electronic engineering from the Marquette University, a master's degree in electrical engineering from George Washington University, and a PhD in law from the New Hampshire University, in addition to being recognized by different journals. So let's start this panel by thanking our guests. So let's start with, please go ahead, with Ms. Carpenter. I do not speak very well, but I'll try to speak a little bit in Spanish. Thank you very much for inviting me here to present to ASIPI. It's an honor and privilege As a professor, I believe, or I spend a lot of time thinking about topics and legal problems of the future. And this Congress is a good example for students, our students, worldwide. Also, I would like to let you know that at 4:30 we have a reception for students hosted by Franklin Pierce, many of our students here, and also for our friends, old and new friends, both old and new friends. Eso sería todo.
Estoy muy nerviosa a hablar
I am very nervous about talking in Spanish.
talk about some of the intellectual property focused legal issues surrounding the metaverse and surrounding kind of metaverse light as it exists right now, as you know, something smaller than what we the potential that we're talking about. And we're going to parse out some of the historical context. We're going to talk about some of the areas of law that may be new, some of the things that have been kind of settled through technological developments over time, and also we'll provide kind of talk about some of the opportunities that exist and how companies and also outside counsel can really add value in this space. So let me kind of get us started here. Okay, this is una imagen del máquina del tiempo.
An image of the time machine.
The time machine. And the time machine is going to take us back in time. And we want to talk about sort of two things. One is the development of technology over time. And then the other one is sort of development of concepts of IP over time. So we're talking about sort of two different markers as technological developments have occurred. And we'll kind of unpack some of the new legal issues that came up at those times that we'll draw on today as we think about kind of a future of the metaverse. And then it's important also to note note the evolution of intellectual property, where, you know, in the past we may have thought of it as patents, mostly also copyrights, trademarks, and sometimes trade secrets if they're lucky. But over time, IP has expanded in so many different ways, and there's so many adjacent concepts that really come into play here. So not just patents, copyrights, trademarks, and trade secrets, but thinking about data and privacy and products liability and contract issues. You know, and especially when it comes to the metaverse, we'll talk more about this. You know, the trademarks in particular are expanding into other areas, and things like licensing are becoming so much more important, perhaps, than they had been in the past. So we're going to go back first to the 90s. We had a debate on whether the cassette tapes really should be the 80s and not the 90s, but we'll stick with this image for now. Back in the 90s, we'll think about the advent of the internet. And one of the things we were talking about last night was just when you had your first email address. And I actually couldn't remember. I think Micky was significantly before I was, because he went to Franklin Pierce, which is a technologically advanced law school, and I did not. So I think mine was probably the late 90s. But it's interesting to think back to those moments of as we all entered this kind of new world.
Para poder entrar
To be able to discuss some specific issues, it's interesting to know how we can go back to the past to learn and know more. When the internet arrived, I would like to ask you, what were the main problems or issues that intellectual property had to resolve at the time?
So I think I may start here. First of all, good morning, everyone, and it's an honor to be able to speak in front of you today. So I think my first email address was around 1993, and that's when you start seeing some of the issues start to pop up. And I think one of the first issues that came up was that of jurisdictional issues, and someone asked the question in the first session about jurisdictional issues, but that was something that was of first impression in the 90s on how to deal with cross-border types of infringement, usage, the difference between territoriality rights and a global footprint. And I think those have largely worked themselves out over the years in terms of where the markets are are trying to be addressed, the contacts that a company has in a given jurisdiction, and so on. And we've seen it play out in terms of companies move from one country to another country to try to avoid laws, and then the laws sort of evolving to address those jurisdictional issues. But I think the one that comes out to me as maybe the most unique in this new forum called the internet was the click-through agreements, right? The agreements that we all don't read and just click and say yes and go on, and whether those are effective or not. Does the individual actually have the opportunity to disagree or dispute, and all the rights that we ended up giving away through those click-through agreements, probably without knowing that we gave them away, particularly with respect to data and data privacy. So I think in contract, those were some of the first things that came up, and eventually those issues were litigated, at least in the United States. Some of those were litigated and found to be valid, but at the same time, onerous terms, maybe are not as effective. On the patent side, I think a lot of the issues had to do around subject matter eligibility. In the US, that's 101. In most other jurisdictions, that's technical effect. And whether a implementation of an invention purely on a computer, manipulation of data, an algorithm that produces other data, whether or not that's actually an inventive concept. So again, something kind of a first impression, and frankly, something that I think we're still struggling with in terms of how to deal with innovations that occur solely on a computer, and whether or not it has a real world technical effect associated with it. So I think that's the first ones that jump up to you. I'll kick it over to you.
Yeah, I think copyright is another area where there were kind of issues of new impression that came out with the advent of the internet, that some of them are settled now, but some of them still persist today, like Micky was saying in the patent realm. One of those, I think, is just the idea of user-generated content, and what do we do with that, especially with regard to platform liability. We had, with user-generated content, all of a sudden you have this kind of decentralized user base that could upload just about anything they wanted, which is not how we treated publishers in the past. And so we had this whole kind of system or legal system to deal with publications and the responsibility that publishers have for content. But with user-generated content and the sheer volume, not just the nature, but the volume, that really sort of threw things, threw a wrench into those established legal principles. Another area that we saw a lot of development at this time was really in the concept of fair use. I mean, we had companies like Google putting, the entire libraries up for free, available on the internet. And so, thinking about concepts of fair use differently and what that might mean in an electronic world was very different. And I think we still struggle with some of those fair use concepts today. In the trademark realm, there were so many issues of jurisdiction. Again, I think was huge, whether domain names were use in commerce. Use in commerce was something we talked a lot about and took a while to get settled. Territoriality, all of a sudden, where the concept of trademarks was so often geographically bounded by location. All of a sudden, there were consumers in totally different areas, perhaps where there wasn't use in commerce, where they were fully aware of those marks, and it has the potential to create a likelihood of confusion, even if there aren't sort of commercial sales happening at that time. The well-known marks doctrine is something that I think can really come into play there. The concept of initial interest confusion, I mean, some of those early cases were really in the adult entertainment industry, but I think, those really stretched beyond where companies realized sort of the power of getting somebody to click on something and then kind of trapping them there. Once you saw something, a shiny object, maybe you would stay on a particular website and buy something there rather than try to navigate out to where, even if you hadn't intended to arrive there at the beginning. And then there were certainly kind of infringement issues around likelihood of confusion, things that, one of the most important things when we think about likelihood of confusion is where are the channels of trade and where are companies advertising. And I remember some of those early cases in the late 90s, early 2000s with would say, you'd read judicial opinions that would say things like, well, they were both advertising on the internet, so there was probably a likelihood of confusion. And you can just think now how absolutely absurd that seems kind of in hindsight. Did you want to say anything about trade secrets? Or?
Maybe just a little on trade secrets. I don't know if it really impacted greatly in terms of it, other than the fact that, as we all recognize, information is at your fingertips. You can find anything about any company or anyone, any topic. Think about all the different searches that you do on a daily basis and the variety of topics that you have. So with respect to trade secrets, I think there were a lot of things that either individuals or companies felt that might have been proprietary, and then recognizing the public nature of so much information available, that it changed the concept of how people thought about they should keep their proprietary information. And was it truly proprietary? Particularly, I'll go back to the click-through agreements. If you've given away a lot of the underlying data rights associated with it, are you really able to keep some of that information private? So I think it started to impact how people perceived how data should be kept.
Mm-hmm. Well, let's build on that. So that sort of sets our foundation. And we're going to talk about the 2000s now. And the development of a game called Second Life, which would be sort of the kind of the precursor in some ways to what we talk about as being the metaverse today. If you're not familiar, this is going to be a clip from The Office, which is a comedy show that was kind of at the beginning of the 2000s. And of course, we now with Netflix, my family rewatches it over and over and over. But I think that this is kind of a, hopefully is a what, are people familiar with The Office? We were debating on whether this is, okay. All right, well, Dwight will describe to us what Second Life is.
Second Life is not a game. It is a multi-user virtual environment. It doesn't have points or scores. It doesn't have winners or losers.
Oh, it has losers.
I signed up for Second Life about a year ago. Back then, my life was so great that I literally wanted a second one. In my second life, I was also a paper salesman, and I was also named Dwight. Absolutely everything was the same, except I could fly.
Second Life es un hito dentro de todo.
Second Life is a milestone within this virtual world, and somehow it is a milestone that can show to us what problems we will face in the future. So I would like to ask you, what problems do you see reflected in Second Life in terms of intellectual property?
And, I think for the first time with Second Life, we envisioned what the potential is for something like the metaverse, where people could develop avatars that would themselves be living a life online. They would be buying and selling property using currency that was, within the individual game. And for companies companies were able to develop online storefronts that were able to engage in new ways with consumers that they just hadn't ever engaged before. And it really also took user-generated content in the copyright realm down a whole different path, because there were users upon users, so it was user-generated content, and all of the attendant problems that exist there. And of course, we're talking in the IP realm, but there also are tons of other legal issues that we could be talking about outside of IP in this kind of context too. In the game, for the first time, usually a lot of times video games will, have contractually sort of own the IP that comes out of that game. But for the first time, Second Life enabled users to actually own any IP that was created as part of their interaction in the game. So we were talking a lot at the time about, this is going to change everything. But did it? It didn't?
It didn't. And I mean, I think in a lot of legal disputes, one has to think about follow the money, right? And Second Life was commercially, ultimately unsuccessful. And because there wasn't a lot of money at stake, I don't think we resolved many of the legal issues that that a platform like Second Life would have presented itself. And I think it's interesting in the clip, if you've noticed how grainy Dwight was, and the fact that it was using it only on a PC. It was a very cumbersome technology. It was very, very hard to use. It was the user interface was difficult. Programming was very difficult. It was very cumbersome, and ultimately, was not a commercial success. And therefore, I don't think we saw some of the legal issues that we think will present themselves in the metaverse didn't really come about in the Second Life era.
So here we are to the present, and we're going to talk about some of the ways we draw on these legal issues that have become settled over time, and then some new issues and opportunities that arise as well. And what we're doing now really is, as a group over these days, is to contemplate what is a future metaverse, a decentralized kind of interactive platform. And what we have now, while we have pieces of it, it is still very centralized with kind of walled gardens of individual environments, whether we're talking about something like Roblox or we're talking about something like Fortnite. And consumers tend to stay in those individual spaces, into those individual games. And here we are in our own avatar. This is what we would look like in Fortnite. I have never done this before, so now I'm really excited to have my own avatar. And so people can create their own skins, as I understand from my 9-year-old. You have skins, and then you can, people create entire worlds through creative modes in each of these kinds of venues, and bring user-generated content to a new level, and have avatars that really engage with each other in these virtual worlds. Now, this also presents a lot of opportunities and challenges that we have for clients that we may be working with.
Igual que en el caso anterior,
Like in the previous case, we will have to ask what are the main issues that the metaverse brings in terms of IP, and how we could have learned or not from the past.
And I think maybe I'll start a little bit with, Luis mentioned my background, that I spent a lot of time at Microsoft. And when I first heard the term metaverse sort of come about, it reminded me a lot of artificial intelligence, in the sense that artificial intelligence concepts have been around for many, many years, decades, but it didn't get the label of artificial intelligence and machine learning and so on until much, much later in time. So it's sort of like the term captured things that were going on already in some amount of time. And I feel like metaverse is kind of the same way. So when did the metaverse start to come to light, I think, commercially for people? Does anyone remember or have a date or a thought? For me, yeah? It started, yeah, it did. The concept started in the 90s times frames, absolutely. I think in popular culture, though, in the last 6 months, specifically October 28th, 2021, that's when Facebook announced the change to Meta, right? And so they sort of announced that, but obviously they were into the concepts of the metaverse much prior to that. They purchased Oculus in 2014 for $2 billion. Right, so the concepts of augmented reality and virtual reality had been around for some time. In the same time frame, Microsoft was developing HoloLens, Google was doing the Google goggles. All of those things now sort of relabeled as the metaverse, or at least the initial carnations of it will be in the metaverse. And I think largely in a way of deflecting the privacy issues that Facebook was dealing with at the time, and sort of refocusing the conversation less on the past and data privacy and more on the future of what this next generation is going to look like. And so that's sort of the first issues that sort of pop up to mind with me. In terms of the legal concepts, though, I sort of go back to those same bodies of law, right? In patents, what is new in patents in the metaverse than before? Well, I think we still have some of the same subject matter eligibility, technical effect types of issues that we saw in the 2000s and the advent of the internet, but we have a much more settled body of law over those last 20 years to deal with those issues. But I really think the main issues are going to come about in the licensing areas around intellectual property. So Dwight was accessing Second Life through a computer. in the metaverse, of course, now we have much faster processing speeds and ubiquitous accessibility and people wearing headsets, as we saw last night. Well, that means there's going to be communication sort of built into the HoloLens. So the same modem that's in a cell phone is now in the goggles. It'll have Wi-Fi 6 in the goggles. So all of the intellectual property issues that I think we'll see in the cell phone industry, we'll start to see repeated in the headsets as well. It also comes to mind a bit of the product's liability side. I remember the first company I was involved in purchasing to support HoloLens back in 2013, 2014. And I think Microsoft paid a little more than $100 million for this company, and it was a lens product, an early version of it, and it had a microprocessor built into the side of the glasses, and it was overheating. So you have this communication chip somewhere between your eyes and your basically on your temple that's overheating. And so I think we're going to see a lot of these types of product liability types of issues when you have such communications really right on your temple. You're sending RF signals, you're dissipating heat. There is a microprocessor there, there is a modem there. So there'll be lots of issues, I think, around those areas.
I'll talk a little bit about some of the trademark issues because that's I think kind of an area where we're getting we need to do a deeper dive, and there's a lot going on. I'll talk a little bit about some of the legal rights issues, whether rights acquisition to protection and enforcement, and then how that's connected also with some of the innovations that we're seeing and some of the risks and challenges that we want to be aware of in the space of legal issues as we go forward. So first of all, just to set the stage, companies don't typically have metaverse arms right now. I think Gucci does, but that's an extremely kind of rare situation. So outside counsel and partnership teams are really important in this space. So as outside counsel, you can add enormous value here, and it's important for you to to be aware of. And help counsel. You can play a significant role there. I guess I'll talk a little bit first in the product placement space, which we don't typically see in these kind of metaverse-light areas. The metaverse gives brand owners a huge opportunity to engage with consumers in new ways. So Epic Games really did create a new world for licensing. And the players don't want product placement. This isn't like a movie. Players want to be players, and there's sort of they have to be tricked into advertising. It has to be subtle and part of the game, rather than product placement. And so we see a lot of licensing collaborations from third-party brands to kind of do something else. We've seen that in Fortnite with Epic Games for Jordan or Balenciaga. And these are really new ways to reach audiences. And I find this incredibly exciting because it's a way to spark excitement around a brand in a totally different kind of venue. Virtual clothing for avatars is one example. And all of this is particularly important because as we see how young consumers make product choices, 70% of teens trust influencers more than traditional celebrities. 82% have purchased something or considered purchasing something after seeing somebody post about it. So this kind of thing can be really influential as well. So one opportunity for brand owners to demonstrate innovation in this space that we're seeing are exclusive items that don't even exist in the real world, but they're released only in-game. And lots of times it's an item increasingly that actually wouldn't work in the real world because brand owners are starting to realize that, oh, hey, we don't have to deal with physics. Like science doesn't matter. So gravity doesn't matter. Dwight can fly. And so because we're not bound by these laws of physics or gravity, there are new products and new markets. So new products that are developed and an opportunity to test them out, whether they would work in the real world or not, and also to explore perhaps on kind of a less costly realm, hey, maybe we're thinking about this new product line, let's also test out this new market. So, you might think about whether, there's some companies that have thought about a new line of backpacks, for example, and have tested the market out in that way, and then produce them in real life. So in that vein, we talked about licensing, and Micky talked about that as being an important part increasingly, and that is a huge component of dealing with trademarks in the metaverse. And also the nature of licensing, the licenses that we're seeing are kind of different. They're much more permissive than we would typically be with trademark licenses. And so we have to think about things like naked licensing. How permissive can we be, as we're working with brand owners to develop licenses without risking jeopardizing those eventual rights. And the licenses go in multiple directions for brand owners. So when they want to use a trademark on a platform, there are going to be licenses from the platform with the brand owners, and then sub-licenses that exist as well, because the consoles need to have licenses, and then there are also needs that the users have. Users are going to have to be able to put clips on YouTube, and brand owners want that. So that's a whole different component, or to play in tournaments and things like that. So the trend that we're seeing is licenses going in multiple directions, and then also those licenses that are less restrictive. There are some terms I think that brand owners should look out for when interacting with the platform, not just terms related to licensing, but also, how are platforms treating user-generated content? I mean, that's certainly an overlap with copyright. How do they deal with infringement? What are their takedown policies? And then what rights are people getting? And when it comes to filing, I think, and this is true, I think, in multiple jurisdictions around the world, people are kind of taking the better safe than sorry approach. So filing in multiple classes, thinking about classes 9, 35, 41. So if brands are going to be active in the metaverse, then really being engaged in that community. So let's talk about, in addition to some of the legal issues that come up, let's talk about some of the risks and some of the challenges that we can expect. Second Life saw some trademark infringement cases, but not many. I think for lots of the reasons that Micky mentioned, it was sort of a failure to launch in some ways, not from the fleshing out of legal issues perspective. And there were more interesting cases, I think, out of Second Life in kind of the real property sense. But to the extent that the metaverse tends to dissolve the constraints, I think we're going to see increasing sort of hybrid lawsuits across both trademark and copyright. So being aware kind of the intersection of both of those bodies of law will be important. One also challenge for companies is that companies really have to engage in this environment. If you're going to play in the environment, and if you're going to be a part of the environment, authenticity is so important to the consumers in these spaces, and they can just sniff out like a fake right away. So they want to know that you belong there. This is an environment where consumers are behaving differently without physical limits. So brand owners should understand, if you're not there playing the game and being a part of it and understanding the roles that take place, then maybe this isn't the space right now for brand owners to be in. Brand integrity is another issue. So we talked about some of the permissive licenses that exist, but that means that your brand may evolve. People may be doing things with it throughout the course of the environment or game. And so another reason it's important for brand owners to be present in these spaces is so they can see what's happening to their brand over time and what's happening to that goodwill to monitor that brand integrity. The monitoring tools that we're all familiar with that have existed in other contexts, we're not there yet with the metaverse. And so the best way to do that is, again, to monitor, is really to engage in that community and with users of the community, to be present and to build a community there, and to track infringement really through users. I think that's kind of covers sort of a spectrum of trademark issues, but I think we're going to see more, because this is an area where more and more brand owners are going to be getting into this space and trying to figure out how to navigate.
One question, or one point of, reflecting back to the back to the 90s, I guess, when we first talked about it, and thinking about copyright. I mean, one of the biggest issues in that time frame with respect to copyright was music distribution, Napster, and the fact that user-based content could, make copies of music and so on. So it's in that era, any level of monitoring by the music industry was a bit futile. It was almost impossible to stop in that era in terms of the proliferation of copyright infringement. Maybe more posing as a question, but now that we're going to have sort of a very analogous realm where users can use trademarks to the same extent that users abused copyrights back in the 90s, are we going to see the same thing? Is monitoring, even if done, going to be effective?
I think that's a great point, and particularly problematic in trademark, because it's, trademarks are all about the goodwill that you develop. And so, I think of trademarks as this storage container for information. And so if a trademark is this, brand owners care so deeply about all of the stuff that goes into that storage container. And that's how, that goodwill is how, they develop their reputation to sell their products. So, losing control over that in some ways is going to be a really sort of uneasy process, I think, for all kinds of business reasons and legal reasons.
I do wonder sometimes, again, reflecting on my Microsoft past, when the copyright, when it was very, very easy to copy software, there was sort of a question posed inside the company, which is, do you enforce the copyright or do you let everybody use it, and so that it's proliferated? And I think Bill Gates's conclusion was, if they're going to copy something, I want them to copy mine. And so they allowed the proliferation of infringement to occur in Windows and Office and so on, and then trying to enforcing things later on. I do wonder, again, taking this back to the metaverse and trademarks, will the mere ability, even if a company wants to enforce those marks, are they going to really be able to effectively do it? And will there be changes in strategy about how to approach it? Perhaps proliferation is better than trying to stamp out every trademark infringement that occurs.
Yeah, and it's not just stamping out infringement, but then also concepts of dilution, which don't exist everywhere. But if you think about dilution and tarnishment and sort of those ideas, how do causes of action for tarnishment of a particular mark exist in a place where there's a lot of generated content around marks themselves and brand reputation as well? So I think we have a couple other areas.
Yeah, one area I think worth talking about a bit is back to privacy again. And the question came up in the first panel as to ownership, right? This is a distributed network, but who owns it? And I think we are seeing the large companies in particular sort of jockeying for position as to ownership of this. I think it's one thing to think about, the Fortnites of the world and the companies that will have some degree of data associated with this. But I think the ultimate question comes down to who's going to own the underlying data that provides for the advertising that would be pushed out into the metaverse, right? So if you're thinking about, for example, if I think about the cloud space today, that's really owned by Amazon, Microsoft, and Alibaba, right? To a lesser extent, Google on the cloud side in terms of that, but certainly from search and ads, that's all Google. So you really have these 3 or 4 companies that effectively owns all the data associated with the directed advertising for it. I think the question that's being posed now is who's going to own the platform? Not necessarily, even if it's a distributed platform, when I use the word owns, it's really going to be who is making the AI insights associated with the activities that are going on there that will fuel the directed advertising that ultimately monetizes in the metaverse.
Yeah, that's a great point. Do you want to touch on any products liability stuff, or?
We can. I mean, I think on the products liability side, as I talked about a bit before, the access to the technology itself is going to be, I think, a big issue to it, whether it's your phone or your headset or so on. But, right now, if anyone's used the Oculus headset and so on, they work pretty well. They're getting there. But I think those, the issues around driver distraction of the individual, or the fact that electronics are operating right on your forehead, I think are still going to present themselves in ways that we haven't seen yet.
So we've really, as we've talked today, and we'd love to just open it up for questions or comments from you all and get your thoughts on these issues as well. As we look back and we kind of traverse the advent of the internet, and there are some things that have been settled there through some of the experiments we saw in Second Life, and then through to the metaverse, there are some areas of law that have developed that and have been largely settled. There are some new opportunities, but one of the things that really struck us as we're thinking through these is that we want to make sure we're not throwing out some great ways to make kind of analogous arguments from well-developed bodies of law throughout these technological developments over time, and figuring out how those might apply in new concepts, but not sort of throwing out the baby with the bathwater. And it's important as we draw on this, though, to recognize that there are a lot of new business opportunities. So perhaps it's not so much about the legal issues, but about new business opportunities and new challenges that are invented, that will occur as we go forward.
I agree, and I think from maybe the legal education side of this, right? Whenever there's a new technology realm, there's always this sort of question of like, okay, are there going to need to be new legal concepts and new ways of addressing this? And I think that's why we took this approach, which is like, when the internet came about, it was really using existing concepts and sort of expanding upon how to apply those concepts in this new environment. And I think we'll kind of continue to see that. There will be new modalities that I don't think we can quite perceive yet in terms of the issues that present themselves, which then I think goes back to the new business opportunities and challenges. Do we think about copyrights and trademarks in terms of a different way, or is it the same methodology in terms of control that companies sort of exert today? And I think we'll see different companies take different approaches to it.
Luis, do you want the final word?
Un tema que tal vez
something that before we start receiving questions is how far legislation will support these changes that we can see. In other words, will it be necessary to make legislative changes or to modify the system to be able to support this evolution?
I'm sorry, I lost you along the way. Yeah, I think that's it. So as we think about ways that, I think it's important to think about whether it's necessary, as you said, to change the laws in order, as these new technologies are developed. And perhaps it's best where we can not to develop some entirely new system. One of the things that we've seen over time, sometimes people will call it, in legal theory, they'll call it like the law of the horse. So, the idea of there are all kinds of laws that might exist that we might want to say, okay, there's this horse. Now let's develop, lots of laws around how to deal with a horse, but there's nothing unique about a horse. It's just, there are all kinds of legal frameworks that we can draw upon. And I think internet law is one of those where we all felt in law schools that for years we had to have an internet law class because you're thinking, ooh, it's the internet. It's a whole different, body of law. But as you start to unpack internet law, you're really thinking about, okay, it's really about a lot of the issues that we've covered today. So there are contractual issues, there are liability issues, there are IP issues, and you're thinking, and so it's not, I think we should be careful not to kind of come up with this compelling need to create a new body of legal concepts, but to really draw on the ones that we have.
Yeah, and I think, as we've talked about this a bit, and you all know from practice, issues don't come to you in a discrete subject matter, right? Issues come into a big mess that draws on, 5, 6, 7 different areas of the law that have to be dealt with. And ultimately, it's a business issue and a business solution that sort of draws from it. So I think that a lot of the advice would be that how to just sort of extend the existing concepts that you've already been dealing with through online practices on the internet and the types of law that applies there and works, and then stretching it onto the metaverse. I do think out of all the bodies of law, the trademark area has the largest learning curve associated with it because of the fact that user-based content, users can put anything on, and the analogy to me is the music industry and copyright. I don't know how the trademark industry can operate in the same way as the music industry thought it could with an online, the advent of an online service. I don't know if being proactive or reactive is necessarily going to make a difference.
Muchas gracias. Ya estamos en el tiempo, así que
Thank you very much. We're past our time, so if you all agree, we can open a space for questions, and we thank you for this excellent presentation and overview on these topics, but possibly much of the public has questions. So please. And how many minutes do we have for questions?
yes.
Oh, sorry, too short.
No tenemos preguntas.
We have no questions? Don't be shy. Please go ahead, Ricardo. Por cierto, Micky, dije 1996, pero pensé que te referías al Internet. Y estoy en Franklin Pierce en 90.
They still had the Max, so I guess it changed.
94 is when it changed.
Yeah, it was 1 year earlier.
Exactly.
I'm just curious. I saw some metaversities out there already, so I'm just curious how you foresee the impact on metaverse in the future of education. I'm sure you have analyzed the issue a lot, but I'm also very curious because, of course, the school is very very into IP. So how do you see education in 10 years?
Yeah, that's such a great question. And I think, one of the things we've been trying to do with our education, especially in the summer, is a great opportunity to do some deep dives into some of these individual topical issues. So we have something called the Intellectual Property Summer Institute that Micky spearheads. And for us, it's a time, there might be topics that are current and sort of related to practice and emerging issues, where it's an opportunity that not to take a class that lasts for 14 or 15 weeks, but for attorneys around the world, also for students to take like a little bit of a deeper dive into specific IP issues, or have a kind of broad overview of an emerging issue. So for example, so we have that taking place right now, and this weekend we have an intensive class on the metaverse. We're doing IP tax, we're doing like blockchain and cryptocurrencies and NFTs. And so I think that education in general is, needs to kind of maintain practical relevance and not worry about being so theoretical, and to really start thinking about what are the practical needs. Because as you guys hire people that come out of law school, you don't want to hire people that don't have any idea how to practice law. You want them to add value right away. I mean, I knew when I graduated that I was going to be losing my firm money for years. And I remember thinking, law school was great, and this is great, but they don't have anything to do with one another. So I think when we think about the future of education in this space, we need to think about two things. One is that people who are getting a legal education need to be able to connect that to the practical reality of what's happening now and then what's happening in 5 years or 10 years. Legal tech is going to be a huge part of it. Some of the things I did as a first or second or third year associate aren't even really done by associates anymore. So familiarity with software and the ability to kind of navigate technology is going to be increasingly important. The other thing that I think is important, and especially for this audience, is that education doesn't just take place when you're in law school. We will all be learning sort of these kinds of things are going to be coming up. It's not just the metaverse and then we're done. These kinds of things are going to be coming up all the time. And so we all collectively around the world need to look at, IP legal education as something that we just do as part of our, as part of our careers, sort of through the arc of our careers. And I think that that the way we used to look at education, where you kind of sequester students away, almost like a monastery or a convent, you sequester them away, get them to study in books, and then release them into the world.
Okay, yes, it's back, I think. Yeah, if I can add to it a little bit, when I think about, so I'll talk about my corporate days at Microsoft more recently, the idea that an attorney, and this goes with your clients as well, as you can be sort of in one vertical, right? The idea that a corporate lawyer is just corporate and a patent lawyer is just patent and so on is really being done away with. And people are forced through the nature of the products that they're covering and that their clients have and so on, that they have to become familiar with multiple bodies of law in order to effectively address the product's issues or the client's issues. And so the thing I'm seeing that's really changed in corporate roles is that, again, this corporate lawyer has to be familiar enough with patent issues, trademark issues, copyright issues, data privacy issues, antitrust issues, and so on, in order to be able to really properly address the concern. So as a challenge as attorneys, I think we've all been trained in a very disciplined, singular side, right? If you become a trademark lawyer, or become a copyright lawyer, or whatever the discipline might be. And the practice has evolved greatly such that these multiple bodies of the law really one has to become familiar with. The biggest issues inside Microsoft occur when the attorney on the front line doesn't even recognize the issue in the early part of a product cycle. And that small problem that could have been addressed early on turns into a huge problem once the product is much further developed because that issue wasn't recognized. So I think it's really incumbent upon all of us as attorneys, regardless of how we were educated, that we really have to broaden our base now and become familiar with other areas of the law that we weren't necessarily trained in.
¿Alguna pregunta más, por favor?
Any further question? Any other question? No question? If there are no other questions, just to mention some additional aspects regarding what it means for professionals and intellectual property in this new environment. I believe that this new relationship that consumers are bringing and demanding for the companies to be supporting this new relationship where somehow it's generating a new environment and necessary links where companies are investing a lot of money to be in. I think more than legal issue is the support required in designing this digital future that the companies need to have to support their clients. And I think we must support these clients in this developing of how to start and be present with the consumers. So as was mentioned by Megan and Micky, more than legal challenges. I think there are new opportunities for business that are being presented, and I think it's a very big opportunity to start seeing this. I think with this, we hope we have covered the questions of our panel, and we ask you for a big round of applause to our speakers who have joined us today.
Wonderful presentation. Gracias, Luis, por tu gran trabajo como moderador.
Thank you, Ruth, for your great work as a moderator. So you're good as far as time. So we finished before, so we'll have 15 minutes for whoever wants to take a small break. At 11:35, next panel starts. 2 announcements. The first one, whoever would like to try the parapenting that Enrique tried, you just write your name. You have to register with the secretary. And to everyone who participated today in this walk run, we thank you very much, especially Pueblo Nuevo Jaco Schools. Thank you who will be receiving this $25 donation. And those who haven't paid, please go to the secretary and pay your $25. And we thank you very much in behalf of ASIPI and of the Social Action Committee especially. So we start at 11:35.